together with my colleague, Professor Dodovski, present a paper. Actually, it's a preliminary study of the different modalities of non-territorial autonomy in North Macedonia. So what we are actually doing is taking as a methodology how we actually structure our presentation and paper. We take the different 5 principles of A.4, which are reflected by the Renaissance model of national cultural autonomy, and we try to explain principle by principle what are the actual situation nowadays in the political system of North Macedonia. So just a reminder of what are actually the principles that we are going to talk about and discuss is firstly characteristics of an NTA, of course, is that minorities do not want to succeed. So succession is not a question of non-territorial autonomy. Minorities are entitled to maintain their distinct cultural identity, language, and cultural customs. Allegiance to the state, so they are loyal to the state, and the state acknowledges the freedom of minority to express and their identity and to protect them from any kind of discrimination measures. The law should not impose an obligation to the state to expend resources just to be able to accommodate minorities' demands, but rather than to include them in the decision-making process of how resources are handled and distributed worldwide within the state. And the effective participation in decision-making process should be also established. This is an overview of statistics, a level of statistics, but these are results from the census. Unfortunately, we stopped in 2002, so there are no significant recent data that will show us what is the percentage of different ethnic communities within the North Macedonia. The struggle of having a census was from 2010 until nowadays, because every 10 days, 10 years census has been made. But there is a political issue here of whether to have or not to have, or what are going to be actually the criteria of having a census and who should actually be involved. So you can see that around 64% are Macedonian ethnic communities, 25 latest data are Albanians, the rest are very small percentage number from the total population. If you can see the replacing nationalities with people and ethnic communities, so just a clarification for those that are not familiar, in 92 when actually was the independence of Macedonia from Yugoslavia, in the constitution different ethnicities within minorities within the country were called nationalities in the preamble of the constitution. Later with the Ohrid Framework Agreement in 2001, then the terminology changed to people and ethnic communities. So in a way, legally speaking, Macedonia does not recognize the term minority, even though it signed the Council of Europe legal documents and Charter of Regional Minority Languages and Protection of Minority Framework Convention, but we don't have a specific terminology as minority. Why this is so? It has been discussed among political parties, especially Albanian political parties in the political arena in Macedonia, that the term minority is somehow not accepted, perceived very well by the ethnic communities, especially by the Albanian ethnic communities. This is why this has been left as a terminology not to be used within the constitution officially. Within the Ohrid Framework Agreement, there is a clear article that says that there are no territorial solutions for ethnic communities. So this is just the first hint, first element of non-territorial autonomy that we can find in the political structure of North Macedonia. Of course, in order to accommodate certain needs of ethnic communities within the country, there was an extension of the self-government units and the self-government structure in terms of use of languages, use of symbols, and participation in decision-making process. The second principle is the distinct cultural identity. So the state should actually provide for promotion and protection of identity. This is done in several levels, such as first the use of minority language in legislative, executive, and judicial branch. From the Ohrid Framework Agreement, there were some conditions to be met in order to be implemented the Ohrid Framework Agreement. So a lot of legal documents have been produced, have been adopted by the Macedonian Parliament. One of those documents, legal laws, were actually the law of use of languages. It has been disputed in many times, and the implementations has been found to be lacking or misimplemented through the years. And with the recent developments in the political arena, especially from 2017, there were discussions of amending the law of the use of languages, and a new law has been adopted. It has been officially published in the official gazette in January 2019 this year. So we are going to see actually how the implementation process will be made. Different legal documents also have been adopted, such as an inspectorate for controlling the implementation of this law, and an agency enabling that this law should be actually implemented. A lot of things not foreseen in the Ohrid Framework Agreement, not foreseen in the previous laws of the use of languages, have been foreseen so far. So the first article says the official language of the country is Macedonian, but other official language, this is the literal terminology that I'm using, other official languages, the language that has been spoken by the people that are more than 20% of the population, in brackets Albanian. So it's clear now in the law that the Albanian is the second official language in the country, and this means that it's applied everywhere. So in the state institutions, in the addressing of the parliament, addressing of the parliamentary committees, addressing in the government, in the banknotes and symbol in the banknotes of the Macedonian currency denar, in the symbol, of course, of schools, naming schools, toponyms like streets. So it's spread actually everywhere. It gives, just a note, it gives one note to the law that when in those municipalities where actually there is no 20%, so the threshold is lower, municipalities can decide by their own if they want to use the Albanian language as a second official language or not. Freedom of association, as in many countries, has been also guaranteed by the constitution and by law. So each civic society organization can be established in order to promote any kind of activities if they want to, but there is no specificity. They can do that for cultural heritage protection and language, but there is no specific minority organization council that are actually existing. Agency for the realization of the rights of communities has been also established de jure, and it has been for a long time established as a law, but the implementation is lacking. So actually the government of North Macedonia is hoping that with the new law and with the new establishment of the inspectorate and another agency, the capacities of these agencies will be further developed. So far they have been only human resources management funded by Organization for Security and Cooperation, by the USAID, and by different single countries, embassies in the country. The third principle is the protection against discrimination, equality of ethnic grounds. So there is a law against any kind of discrimination, and there is the question of the loyalty to the state. It is a question that is philosophically, very interesting to answer. What is a loyalty to the state, and how a citizen is loyal to the state? What we actually argue within the paper is, of course, the contract theory, citizenship. You get the citizenship and you assume that you are loyal to the state. On return, you ask a protection from the state. So this is the basic thing that you actually ask from any of the citizens, whether they are loyal or not loyal to the state. Any kind of argument or a legal ground has not been existent so far. Fourth principle is greater ownership in decision-making process about the resources. So this is also connected with the fifth principles, that the ethnic communities are allowed to take to participate in decision-making process. The first thing is the Belgrade majority voting principle that is applied within the parliament as well as the local level. So it's a majority of the representatives from the ethnic communities that they need to vote additionally for a certain law that is in the area of the protection of the ethnic communities. I will just go through because I don't have time. Maybe with the questions we can clarify some things. And the fifth one is that there are different kind of also institutions within the parliament and the local level that ensure additionally de jure participation of ethnic communities in the country, such as the Parliamentary Inter-Community Relations Committee and the Commissions for Relations between communities on a local level. There is also the proportional electoral model, which allows for the political parties with ethnic background to participate in the elections and to be elected, as well as the coalition forming structure, which is done since the independence of the country. What we can conclude at this moment is that there are no pure NTA minority councils or organizations within the structure of North Macedonia, but we know how the position of the Albanian ethnic communities, but NTA, we are assuming that it's not particularly interesting for them because they already had additional rights that were established within the structure, but we are willing to able to investigate further whether NTA could be a possibility for smaller in size, as you saw in the census, smaller in size communities, whether it will be additional measure that they can use in order to be more heard, more promoted, and to have more possibilities to have their right as ethnic communities within the country. Especially, we are going to see and we are going to monitor the realization of the implementation for the Agency for Realization and Promotion of Ethnic Communities in the country. Thank you, and I'm sorry if I breached a little bit the time. Thank you very much.
You say there are no NTA associations.
Yes.
Does it mean there are no minority associations?
Associations are founded by the law of the freedom of associations for any kind of interest and reasons, from sport to cultural activities, from think tank research organizations to, I don't know, agricultural activities. So this is a very broad term. What I mean about NTA, I mean the examples of Serbia, examples of Croatia, examples of Slovenia. We don't have that kind of characteristics in North Macedonia. So ethnic, as a member, for example, I'm Albanian, a member of an ethnic community, I can form an association. It can be for promoting the language and the culture of the Albanians, but it is within that purpose only. It doesn't have a right to elect any kind of representatives to be further involved in the decision-making process at local level or at a state level. So it's just limited for promotion of cultural activities. It's not limited for deciding whether there will be financial resources for their activities. So this is completely different things. It's not. It doesn't go beyond of deciding whether we are going to have some money from the institutions in order to fund our activities or not. We just wait for the money to be arrived.
But they do exist.
Yes, they exist. Of course. Yeah.
What do you think about the next census expecting in next 3 years or maybe even earlier? Will it change maybe the fifth principle decision-making process regarding the fact that informally there is much more percentage of Albanians in Macedonia? I'm very often there and I'm speaking with the colleagues, and I know that there is probably now almost 40% or even more Albanians. What do you think? I know it's very difficult, and maybe even can help us with that, but I think it will have some challenges in political processes in the future in North Macedonia.
There was an attempt to have a census, and it failed. there was an indication that it was due to the fact that political parties, the ruling at that time political parties of Macedonians and ethnic Albanians, realized that their expectations are not going to match with the actual results. The fact is that there is massive immigration, and the number both of Macedonians and Albanians is declining. The suggestion is that if we had the census and the numbers were correct, that is, not manipulated, it would have happened that we have perhaps slightly less than 20% of Albanians, which then would be a problem because it will, jeopardize the whole political setup, saying that the Albanians which are above 20% have the particular rights that they have gained thanks to the Ohrid Framework Agreement. So, for various reasons, or avoiding risks, this has been postponed, and the newest suggestion is that we'll have the census only in 2021.
I just wondered if you could say how then are the local commissions, how is membership determined in those? And the second one is broader, and it goes back to Ephraim's lecture and also Pete's paper yesterday. And Ephraim said, consociationalism is the best known form of NTA. In that sense, would you say that the Ohrid Agreement should be characterised as a consociational arrangement, or is it something else?
My response to the second question is not 100%. It does include consociational elements, but not fully. Well, some of the elements that Marina mentioned are clearly consociational. For instance, the Badinter principle, where you have to have the agreement, the voting of the ethnic minority representatives, and if they don't have the double voting, then whatever you want to pass would not pass in the parliament. That's clearly one very strong element of consociation democracy. But then again, there are other elements which are missing from the, let's say, traditional consociationalism, and therefore it's a mixed model, I would say. Whereas the first one you can answer.
Yes, in the municipalities, wherever there is a higher percent, like above the threshold of 20, the municipalities have an obligation to establish committee for inter-ethnic relations, whereas not, the municipality can decide whether to establish or not. It is their own discretion in terms of the law. In practice, it has been found out that even though there is an obligation, and it is founded, you can see it in the statute of the municipalities that is existent, the work is lacking. There is no work at all. So there are some issues at local level that are concerning ethnic communities living at local level, but the decision in the council, in the local council, have not been made in that way to consult the inter-ethnic relations committee. And the committee has been founded for that reason, to have a consultation and to vote with the same Badinter double majority principle on different kind of legal acts at local level that concern ethnic communities. Those council members that are members of the ethnic communities, they are part of the committee. So this is the local level council members. It is not allowed for a citizen living at that municipality to be part of the inter-ethnic.
So you show a slide initially where you have data from the early 2000s, right? And then you say that that's the last census. That was done, and we have the explanation as to why this is the latest data that we have. And then in the rest of the paper, it seems that most of the mechanisms that you describe pertain to the Albanians. And so I wonder if, I haven't read the paper obviously, but it seems useful to distinguish the mechanisms that are in place for the Albanians and the mechanisms that are in place for the others. Because it seems that you're mostly talking about the Albanians Because as far as I can tell, there's no municipality, for example, local municipality, where the threshold of 20% would be met by the Turks or the Roma. So the paper is really about the two main groups in northern Macedonia, and the rest of them, they're not really, as far as I can tell from what you were saying, these mechanisms don't really concern them directly. Is that what you were saying?
The mechanism that I explain are actually for the whole territory of North Macedonia. The distinct feature is the threshold where you can use the language as official language. But the rest of the mechanism are actually guaranteed de jure by the Ohrid Framework Agreement and by the different legal documents produced after the Ohrid Framework Agreement, where they say that actually the terminology is that the ethnic communities in general. So if you find yourself there in a certain municipality, you are entitled for this kind of right of protection. And there are municipalities where actually you can find, for example, Roma, you can find above 20% that are on a local level. So they can use this mechanism as a threshold, for example. It seems from the data that it's only for the Albanians, but the mechanism has been constructed to include all of them. In practice, this is not happening. This is what we are actually saying, that maybe with the agency and with the other NTA mechanism that we are wanting to explore with Professor Dodovski to see if that could be an addition to what has actually been established in Macedonia, to be able to give them more space and more opportunities, such as at the local level. They should be actually more promoted.
Sorry. If there is a census and the Albanians are less than 20, we have something in law that is called acquired rights. That means it's very difficult to reduce the rights which are already established. But now what's the problem? The problem is what about the other communities which are less? Let's say I'm working within the Turkish community. Do you think that setting that will never reach that threshold, or maybe they are bigger number now in this very moment? Do you think that is just or right in such an agreement or framework establish thresholds? By your opinion, do you think that the thresholds are necessary so the system can function?
My personal opinion is that thresholds should be established because there should be a certain kind of number to be able to actually exercise some certain rights. What I actually prefer is to see smaller minorities using NTA as a characteristics in Macedonia. Personally, I really want to see functioning of an agency at local level. I really want to see inter-community relations at local level, not only in those municipalities where it is above 20%. I want to see them in less than 20%. This is what I want to see. I want to see a beginning of an implementation that has already been established by the law. And after we are going to see this, whether it is functional or not, because we need to, test it. After we're going to see, then maybe minority councils, such as in the NTA models in the neighboring countries, could actually be of some help and could be effective. This is, a hypothesis that I really want to see actual on ground.
Okay, I'm afraid we have to stop there.